Okay, we're here with Matt Wood of Free Press, and we're in the FCC hearing for net neutrality. What can you tell us about your expectations?
Well, it's the big day. It's not the end of a process, though. They're just starting this process, and they'll be asking about what rules they should adopt. Really, today they're just proposing them. We've thought all along that the rules the chairman wants to propose are not going to be good enough to do the job, which is why we've been protesting, and so many people here in D.C. and around the country protesting them. And we hear that he's open to having that discussion about making the rules better. We just need to keep pushing to make sure that we actually have that discussion and that there is the political will and the legal ability to enforce these protections when the FCC makes the rules.
I read somewhere that there have been 2 attempts at this that failed in the Supreme Court. Is that correct?
Yeah, well, actually, not the Supreme Court, a little bit lower, but 2 times since a Supreme Court case, they've tried to have these kinds of rules, and both times have been struck down. One time Comcast sued and won, and the next time it was Verizon. So big telecom and cable companies who do not like these rules for kind of obvious reasons. It gives them less control. We think they're necessary to give people more control over their broadband connections, and we don't want to see a third time trying and failing in court.
Okay. Margaret Flowers from Popular Resistance this morning said that this is phase 1 of the fight to save the internet. Right. How are you seeing phase 2 over the next coming months?
So yeah, it'll be a pretty short but intense phase between now and when they actually vote on today's proposal. There's a lot of steps in the bureaucratic process, so today they have to vote to put the proposal out there for public comment. And then at the end of that time period, probably 3 or 4 months, same 5 commissioners will have to come back and vote on the proposal and say, we've heard the public comment, here's how we've changed our ideas, here's how they're the same, here's what we're going to do. After that, it could go back to court yet again if one of those big internet service providers tries to sue again. So there's really never an end to the process, unfortunately. It's a constant dialogue between the public and these government officials and the companies who have a stake in this too. And we think sometimes an outsized voice here at the commission. But what we're trying to do with all of the people who have been so tremendous over the past week making their voices heard is keep those voices loud and constant and make sure people inside this building can hear them.
Okay, can you tell us about SaveTheInternet.com?
Sure, yeah, that's a website that Free Press and a lot of other groups launched almost a decade ago now, and it's just a resource at this point for materials on things that many, many different public interest groups, Popular Resistance, and Fight for the Future, and Free Press, and Demand Progress, a bunch of groups who come at this from pretty much the same standpoint, but have different voices, different strengths, different takes on the issue. We're trying to collect as many resources there as we can to tell people how they can make a difference by sending emails, by making phone calls, by coming to DC in person, by talking to your member of Congress. And there's lots of different channels just by talking about it to people that you know. So anything we can do to raise awareness of this important issue and make sure that when people are concerned, they don't just kind of hold those concerns to themselves, but they make them known and especially tell people right here in Washington about them.
Okay. And thank you to Matt Wood of Free Press.
Thank you.
Again, this is Robert Perona of DC Media Group. Thank you.
Enjoy.
I speak on behalf of the internet generation. I grew up on a free and open internet. We want to declassify ISPs as Title II common carriers. A common carrier is required to provide service in general terms and indiscriminately. Declassify ISPs as Title II common carrier. Save the free and open internet!
There is one internet. Not a fast internet, not a slow internet, one internet. The attention that is being paid to this topic throughout the country, here in this room, is proof positive as to why the open and free exchange of information must be protected. Thank you to all of those thousands who have written me personally about this. Thank you to those who feel so strongly about this that they've been living in tents outside of the building. And I enjoyed our meetings. One can only conclude that the Founding Fathers must be looking down and smiling at how the republic that they created is carrying out the ideals that they established. By releasing this item today, those who have been expressing themselves will now be able to see what we are actually proposing. They have been heard. We look forward to further input. And I say thank you for your passionate caring about this very important issue. But today we take another step in what has been a decade-long effort to preserve and protect the open internet. Unfortunately, those previous efforts were blocked twice by court challenges by those who sell internet connections to consumers. Today, this agency moves to surmount that opposition and to stand up for consumers in an open internet. There's been talk up here about freedom, about whether or not there's been market failures. The D.C. Circuit, in its opinion on the 2010 decision of this commission, made an interesting observation that I'd just like to quote. Quote, "There is little dispute that broadband providers have the technological ability to distinguish between and discriminate against certain types of internet traffic." Unquote. The court found. There have been examples of abuses from individual cases to mobile carriers denying access to apps for banking or voice or video. So this notice of proposed rulemaking starts an important process. Where it ends, we'll learn during the process. That's why I'm grateful for all the attention that this has received. We start with a simple, obvious premise. Protecting the open internet is important for both consumers and economic growth. We are dedicated to protecting and preserving an open internet. As Commissioner Clyburn much more eloquently pointed out, what we're dealing with today is a proposal, not a final rule. With this notice, we are asking for specific content on different approaches to accomplish the same goals, an open internet. Nothing in this proposal, by the way, authorizes paid prioritization, despite what has been incorrectly stated today. The potential for there to be some kind of a fast lane available to only a few has many people concerned. Personally, I don't like the idea that the internet could be divided into haves and have-nots. And I will work to see that that does not happen. In this item, we specifically ask whether and how to prevent the kind of paid prioritization that could result in fast lanes. 2 weeks ago, I told the Convention of America's Cable Broadband Providers something that's worth repeating here. Quote, "If someone acts to divide the internet between haves and have-nots, we will use every power to stop it. I will take no backseat to anyone that privileging some network users in a manner that squeezes out smaller voices is unacceptable. Today we have proposed how to stop that from happening, including consideration of the applicability of Title II. As I said, there is one internet. It must be fast, it must be robust, and it must be open. The speed and quality of the connection the consumer purchases must be unaffected by what content he or she is using. And there has to be a level playing field of opportunity for new ideas. Small companies and startups must be able to effectively reach consumers with innovative products and services, and they must be protected against harmful conduct by broadband providers. The prospect of a gatekeeper choosing winners and losers on the internet is unacceptable. Let's stop for a minute and look at how the internet works at the retail level. The consumer accesses the internet using connectivity that they have purchased from an internet service provider. That connectivity should be open and inviolate. It is the simple purchase of a pathway. I believe it would be commercially unreasonable and therefore not permitted under this proposal for the ISP not to deliver the contracted for pathway. But let's consider specifically what that means. I want to get rules that work like this. If the network operator slowed the speed below that which the consumer bought, it would be commercially unreasonable and therefore prohibited. If the network operator blocked access to lawful content, it would violate our no blocking rule and be commercially unreasonable and therefore doubly prohibited. When content provided by a firm such as Netflix reaches the consumer's network provider, it would be commercially unreasonable to charge the content provider to use that bandwidth for which the consumer had already paid, and therefore prohibited. When a consumer buys specified capacity from a network provider, he or she is buying open capacity, not capacity that the network provider can prioritize for their own profit purposes. Prioritization that deprives the consumer of what the consumer has paid for would be commercially unreasonable and therefore prohibited. Simply put, when a consumer buys a specified bandwidth, it is commercially unreasonable, and thus a violation of this proposal, to deny them the full connectivity and the full benefits that connection enables. Also included in this proposal are two new powers for those who use the internet and for the Commission. Expanded transparency will require networks to inform on themselves. I call it the rat-out rule. The proposal expands the existing transparency rules to require that networks disclose any practices that could change a consumer's or a content provider's relationship with the network. I thus anticipate that if a network ever planned to take action that would affect the content provider's access, there would be time for the FCC to consider petitions to review that action. This proposal also creates a voice for the average American. Recognizing that internet entrepreneurs and consumers shouldn't have to hire a lawyer to call the Commission's attention to a grievance, an ombudsperson would be created within the FCC to receive their complaints and, where warranted, investigate and represent their case. Separate and apart from this connectivity is the question of interconnection or peering between the consumer's network provider and the various networks that deliver to that ISP. That's a different matter. It is better addressed separately. Today's proposal is all about what happens on the broadband provider's network and how the consumer's connection to the internet may not be interfered with or otherwise compromised. Now, the situation in which this commission finds itself is inherited from the actions of previous commissions over the last decade. The D.C. Circuit's ruling in January of this year upheld our determination that we need rules to protect internet openness, and upheld our authority under Section 706 to adopt such rules, even while it found that portions of the 2010 Open Internet Order were beyond the scope of that authority. In response, in February, I promptly stated that we would reinstate rules that achieve the goals of the 2010 order using Section 706-based roadmap that the court laid out. That's what we're proposing to do today. Section 706 is one of the two principal methods proposed to accomplish the goals of the open internet. Today we're seeking input on both Section 706 and Title II of the Communications Act. We are specifically asking for input as to the benefits of each and why one might be preferable to the other. We've established a lengthy comment and reply period sufficient to allow everyone the opportunity to participate. Commissioner Clyburn made an observation, personal point with her mother. I'd like to make a personal point as a former entrepreneur and very capitalist. I know the importance of openness firsthand. As an entrepreneur, I have had products and services shut out of closed cable networks. As a VC, I invested in companies that wouldn't have been able to innovate if the network weren't open. I've had hands-on experience with the importance of network openness. And I will not allow the national asset of an open internet to be compromised. I understand this issue in my bones. I've got scars from when my companies were denied access in the pre-internet days. The consideration that we are beginning today is not about whether the internet must be open, but about how and when we will have rules in place to ensure an open internet. My preference has been to follow the roadmap laid out by the D.C. Circuit in the belief that it was the fastest and best way to get protections in place. I've also indicated repeatedly that I'm open to using Title VIII. This rulemaking begins the process by putting forth the proposal, asking important and specific questions, and opening the discussion to all Americans. We look forward to the feedback on all these proposals. Now we will proceed to a vote. All those in favor, say aye. Aye. Opposed? No. The ayes have it. The order is adopted. The request for territorial privileges is granted. Now, before we move on to our next item, I'd like to note that the order will be slightly different for the next two items. We'll first hear presentations from the FCC staff for the next two items, followed by statements from the bench on both items. After that, we'll proceed to individual votes on each of the two items. So, Madam Secretary, would you please announce our next item, and to the Bureau and also Council staff who will